Okay, welcome to the video for class 2, in which we're going to be launching into our substantive discussion of intellectual property doctrines. But we're going to be doing it in an interesting kind of way by talking about the concept of misappropriation of information, which may or may not technically be a form of intellectual property in the first place. So the background principle here is that in general, intellectual property doctrines like copyright, like patent, like trade secret don't generally provide any exclusive rights or protection in factual information about the world that's publicly available to anyone who is interested in knowing it. So this isn't the kind of thing that's normally protected. Why not? Because we normally think that people should have broad access to and use whatever factual information is available. So that's actually kind of the premise of a lot of intellectual property law. And as a corollary, or in addition to that, in general, intellectual property law is intended to, at least in many respects, promote competition. In other words, we want people to compete to produce more and better of the forms of information goods that intellectual property is intended to encourage. But, there's a big but, there's a caveat here, which is that intellectual property doctrines and principles are also sympathetic, at least in some cases, to the concept of unfair competition, right? In fact, you might even say that the whole premise of intellectual property rights in the first place is to prevent unfair competition in knowledge goods. Unfair in the sense that it recognizes that there's investments of time and energy in producing knowledge goods, and then it would be unfair to allow third parties to reap the benefits, as it were, of those goods in competition with the person who invested in producing them in the first place. In other words, when somebody invests the time and energy in producing a form of knowledge good, right? Whether that's an invention or discovery, a work of authorship, a distinctive mark invested with goodwill in the marketplace. How do we know when it's unfair, or if it's unfair, for somebody else to use that knowledge good or something similar to it in a way that arguably competes with the person who created it? So we'll be exploring that question outside the traditional scope of intellectual property doctrine in the realm of the state tort of misappropriation, right? So in theory, this isn't an intellectual property doctrine at all, but I think you'll see that it kind of sounds in a lot of the principles and ideas that inform what we're concerned about when we talk about intellectual property law. So we're first going to take a time machine back 100 years to 1918 to look at the case INS v. AP, right? This is sort of a touchstone for the concept of misappropriation and the various kind of justifications and concerns associated with the concept of misappropriation of information as being a tort, or as being a harm that we want to recognize legally in the first place. Okay, so what's the background to this case? Well, we have INS, International News Service, and AP, Associated Press. Both of these are what's known as news aggregator or news generation organizations, as it were. And Associated Press, of course, is still with us and is in fact the largest of these newswire organizations, still producing a lot of reporting, which is then carried in a lot of other newspapers for a fee, right? In other words, newspapers become members of one of these news generation, these wire services, as they're known, right? And they pay a fee in order to be permitted to reproduce the news that these services circulate. Okay, well, in 1920s, really at the peak of the importance of newspapers, which are the key method for disseminating news at the time. And we've got a conflict between two of these news aggregating, these newswire organizations, right? Both of which are trying to report on the ongoing Great War, World War I in Europe, right? So this is the big news story of the day. Everyone wants to be reporting on this news story. The problem is that INS is being locked out of access to correspondence, putting correspondence on the ground and kind of gathering news in the European theater by the British and French, because it was perceived as having a pro-German slant early in the war. So kind of retaliating, the countries are retaliating against INS for its perceived bias and not permitting INS to have the same access that other news reporting agencies are getting. Accordingly, the Associated Press is able to gather a lot more and a lot more valuable and a lot more interesting news about the progress of the war than INS is. And AP is shooting this news back to the United States over the then new telegraph wires, so it can be printed in United States newspapers that are AP subscribers that then distribute this news to the public. Okay, so how does this play out in practice? Well, AP gets the news on the East Coast of the United States and puts it into the morning editions, early morning editions of the newspapers. And those, those stories are also posted up around town on these bulletin boards that people can go to and see what the big news of the day actually is. So AP's got a monopoly over breaking that news on the East Coast in the Eastern time zone. Right? INS can't get it first because INS doesn't have correspondence on the ground in Europe. Therefore, they're hamstrung, right? They can't report on the news as effectively as AP. They can't actually compete on the East Coast. But remember, there's a time difference and there's a 3-hour gap between the East Coast and the West Coast. What INS can do is gather that news, not from Europe, but from the Associated Press newspapers and bulletin boards, and use telegraph wires to shoot that news to West Coast newspapers at a lower price to encourage them to buy their news from INS instead of AP. Now, what are they doing? Well, they're copying all kinds of stuff. Presumably in the real world, they were in fact actually copying entire stories in some cases, which would have potentially been a copyright infringement, although AP had not actually registered copyright in a lot of the areas. It's complicated. In any case, in the stylized facts of the case in question, what INS was doing was copying the facts out of the stories and then rewriting the stories, incorporating those facts to produce its own literary works that encompass the facts or that express the facts that had been gathered by the Associated Press. So basically, it was creating its own stories using the building blocks gathered by the Associated Press and then selling those stories on the East Coast. Now, of course, the Associated Press could just as well have sent those stories all the way out to the West Coast initially itself and scooped INS all the way across the country. The problem was that that wasn't in its economic best interests, right? Because if you put the newspaper out at 5 a.m. for the early morning risers on the East Coast, well, that's 2 a.m. on the West Coast. That's not a economically attractive time to be breaking news and selling newspapers. So what AP really wanted to be able to do was stagger across the country when it was breaking the news. So, break it at the same local time in every time zone, and INS's actions were preventing AP from doing that. In other words, AP could maximize revenue by being the sole source of breaking news on the East Coast, but it couldn't be the sole source of breaking news in every time zone at the respective time because INS was undercutting that. Right? So that was, at the end of the day, ultimately AP's real kind of business objection to what INS was doing here, beyond the fact that it just didn't want INS to be benefiting from its news gathering at all, right? INS is a competitor, or at least theoretically a competitor of AP. There's some question about, whether it's cross ownership that made them really not as competitors as all that, and whether or not this case was really as honestly litigated as we might otherwise want cases to be. Here you see pictured William Randolph Hearst, who the great, newspaper magnate tycoon, who actually owned most of both INS and AP, so sort of on both sides, same owner on both sides of the same lawsuit. It's not entirely clear that the litigation went as honestly and as fulsomely as it might have. Regardless, we get an opinion from the Supreme Court authored by Justice Pitney, finding in favor of the Associated Press and saying that INS had engaged in improper behavior. And what's interesting is the basis for that conclusion. So essentially what Justice Pitney says is, look, it's true that facts about the world are typically not the kind of thing that's protected, but nevertheless, AP has invested time and energy in gathering and generating these facts, and as a consequence, it has a quasi-property interest in the facts, and in particular, it has an interest against unfair competition, which is what INS is doing, right? INS isn't investing the labor in generating those facts, right? It's just lifting them from the Associated Press stories. That's unfair competition because AP has a legitimate interest in essentially extracting the value from the facts, the valuable facts that it's generating. What's more, Pitney says, look, INS isn't even properly crediting this to the Associated Press, right? They're just taking the facts and rewriting them. They're not crediting the Associated Press as the source. So there's a kind of quasi-plagiarism, as it were, going on as well, insofar as the INS isn't crediting, isn't properly attributing the facts to the source that generated them. And ultimately, Pitney says, look, that's misappropriation, because even though those facts are available to the public, availability to the public isn't the same as availability to a competitor in terms of how we conceptualize unfair competition. And AP deserves to have a longer period of exclusivity than INS's current business practices are allowing it. Therefore, we're going to prohibit INS from doing what it does. Now, we've got some dissents here from both Holmes and Brandeis on slightly different grounds, right? So Holmes essentially says, look, this isn't the kind of thing that copyright protects. Facts are facts. Once they're known to the public, anyone can use them. Copyright is limited in terms of what it protects, and it explicitly excludes facts from protection. So when INX takes those facts and rewrites them into new stories, it isn't doing anything wrong, and there's no basis for AP to be bringing a claim against it on those grounds. Now, maybe AP has a claim against INS on the grounds that there's a failure to properly attribute, but INS ought to be able to do what it's doing with respect to the facts, so long as it discloses where it obtained those facts from. And then Brandeis takes that on one level, one step further, saying that not only is there no copyright protection for facts, but there's really no obligation to attribute facts either. And Brandeis, in his kind of realist New Dealer kind of way, says, or proto-New Dealer kind of way, says, look, if the legislature wanted to create quasi-property interests in facts in order to motivate more robust news gathering, then presumably it could do so in the public interest, but it would also regulate the charges and the scope of those rights as well. We don't have that legislative superstructure, and courts shouldn't be imposing it sort of through common law rulemaking. They should leave that kind of thing up to the legislatures. That's the legislature's decision if it wants to create property interest here. It hasn't, and so we shouldn't be wading into that pond. So the question really is, how ought we to think about questions like this one? I mean, accepting the stylized facts as presented by the Supreme Court, is it unfair competition what the INS is doing? What do we mean by unfair? What makes competition unfair? What's AP entitled to, if anything, and why? And are the assumptions that the court makes about the incentives that the Associated Press has and how they might be affected by INS's actions actually legitimate, compelling, convincing, the kind of thing that we may think makes sense, right? I mean, let's assume that INS was permitted to continue to essentially crib facts from the AP's East Coast editions and use them to generate its own competing versions of those stories on the West Coast. How would that affect AP's incentives at all? Do you think AP would stop gathering news, start releasing news differently? What do you think the consequences would be? Would those consequences be bad? Would those consequences be unfair? What does it mean for the consequences to be bad or unfair? And is there any room to kind of generalize to how we think about how journalism takes place today? After all, these days, a lot of news gathering organizations complain over and over and over again about people taking their stories without permission, or essentially unfairly competing with their expensive news gathering activities by simply lifting the facts and rewriting their own stories, kind of free riding, as it were, on their journalistic investments. Should we be concerned about that? Is that a problem, right? How should we conceptualize those kinds of questions in a modern 21st century internet-based context? Okay, well, we can also conceptualize those in relation to the theories of intellectual property that I discussed yesterday, right? I mean, insofar as we think about them in terms of consequentialist theories, are the consequences of allowing this kind of competition likely to be good or bad? And how should those consequences inform our assessment of the rightness or wrongness of allowing for there to be some form of protection of factual information? And to the extent that we have concerns about the moral rights of the parties involved, is there a moral kind of question being presented here? Right? Does the act of engaging in gathering information, journalistic information, create a kind of moral right for the Associated Press, or is that the wrong way to think about it? And insofar as we can think about the Supreme Court's opinions as being informed by these different theories of justification, sort of how might we characterize those different opinions in relation to these theories? How do the justices think about the justification for what they're doing, if it fits within these frameworks at all? Okay, so let's now zoom back to the present and think about two other cases that engage with similar but meaningfully distinct problems. So in Reed v. McGraw-Hill, we've got two different companies that are engaged in the business of running what are known as construction product info databases. Essentially, they compile information about construction projects, which they then sell access to this database to consumers, presumably contractors of various kinds who are looking to bid on different projects. And this is a convenient and efficient way for them to identify projects that would be appealing for them to bid on. And of course, they're Reed and McGraw-Hill are trying to sell their products. They're competing against each other to sell access to their products to different consumers. You might kind of analogize to Lexis and Westlaw. Here we're in law school, you can mix and match and try whichever one you like. They're offering free access to both. But in the business world, these are expensive services, and Lexis and Westlaw compete with each other to get customers, because people are going to buy one or the other. They're going to use one or the other, and the two services want to compete against each other. How do they do that? Well, they compete against each other primarily by providing better services. So what's going on here? Reed says that McGraw-Hill is unfairly competing with it, right? By hiring people to essentially get access to Reed's data set by pretending to be Reed customers, but actually being spies, right? And gathering information and then using that information in ways that are unfair to Reed, both by providing unfair, skewed comparisons, and also by taking information from Reed's data set and putting it into McGraw-Hill's data set. Now, the problem here, of course, as with INSVAP is that neither Reed nor McGraw-Hill owns this data in any traditional sense, right? I mean, they simply know that it's true about the world and they're including it in their data set. Normally, information that's true about the world isn't the kind of thing that you can own. But Reed points to the fact that in order to get access, you have to make all these agreements and representations to Reed about who you are and how you're going to use this data, and that the people hired by McGraw-Hill are violating those agreements and doing so in an unfair fashion. Well, McGraw-Hill files a motion for summary judgment, and ultimately the district court denies the motion on the ground that Reed has in fact made out a case for unfair competition under the principles of INSVAP. So a real kind of century-long story here of INSVAP informing how courts think about these kinds of problems, at least arguably, right? Saying that, look, McGraw-Hill is in effect free riding on Reed's work. Reed compiled this information, and McGraw-Hill is improperly getting access to this information by hiring spies, and that sufficiently pleads a claim of unfair competition such that the action could go either way for a reasonable juror. So what do you think about that? I mean, is that what we mean? Is this really a case of unfair competition, or is it just a case of arguably, violating terms of the contract? And if it's a contract violation, do we need an unfair competition tort? Is there really anything unfair happening here at all? And to the extent we care about consumers, who are the consumers here? And is the outcome that the court is reaching consistent with maximizing the interests of consumers or not? In other words, how should we think about the justification for these kinds of decisions? What are we trying to accomplish? And is the court's decision here consistent with kind of broader values about what we actually want to see happen? In other words, to the extent that this is a form of competition, is it unfair? What does it mean for it to be unfair? And what do we want to see actually happening from a policy perspective? Okay, and then finally, let's look at the HighQ Labs v. LinkedIn Corp case. Well, you're all probably familiar with LinkedIn. It's sort of like the boring business version of Facebook that people use to look for new jobs. You probably know more about it than I do. I sort of accept every LinkedIn connection request without really knowing exactly what it's for. In any case, HighQ Labs is in effect trying to offer an additional product here, where they want to enable companies to identify employees who are potentially looking at new jobs, or how can companies use LinkedIn data to maximize their personal management decision-making processes? Well, how they go about doing that? Essentially by scraping data from LinkedIn, which LinkedIn doesn't like on one level, because it says, well, we've got all these agreements with our users that we're going to protect their data, and you can only access in certain ways. And we have these end user license agreements, and we have different terms of service that you have to agree to in order to use the product, blah, blah, blah. But of course, LinkedIn is also thinking about creating its own similar product that would be marketed to businesses looking to inform their personal management decisions. So there's this kind of idea that there are potentially competitors here, and HighQ is looking to get data from LinkedIn. In any case, HighQ is in effect literally filing a declaratory judgment action, trying to say that we're not doing anything wrong and LinkedIn should stop trying to frustrate our business. LinkedIn is responding with a counterclaim for unfair competition and misappropriation, effectively unfair competition through the misappropriation of information from its site. And HighQ is asking for the court to dismiss that. That's a pretty high bar. It's like essentially saying that LinkedIn can't make this claim as a matter of law. And the court says, no, we think that LinkedIn might be able to make out a misappropriation claim here. After all, insofar as there's the potential for competition, there is the potential that there was some form of subterfuge being engaged in by HighQ in order to gather the information, and therefore LinkedIn can at least proceed to discovery, presumably, on the misappropriation claim in question. Now, what do you think about that? Is that the right outcome? Is HighQ Labs really misappropriating anything at all? After all, this is information available on people's LinkedIn pages that any member of the public can see, right? In some sense, it's not so different from INS walking down the street or picking up a copy of the newspaper and seeing the news and using it itself. Is that the kind of thing that ought to be the subject of a misappropriation claim? Or is, once it's on the internet and perceivable by any member of the public, right, should it no longer be protected? Does it matter that there's a potential for competition? Should these kind of quasi-property rights only be rights that are assertable by competitors? And what would be the benefit or harm of allowing or disallowing exclusive claims among competitors over this kind of information? A lot of difficult questions to answer. Let's think through the policy questions in class.